Testimony that you give while under oath concerning the alleged offenses could and would likely be used against you at a later trial if I were to not accept your plea for some reason, or if you later withdraw your plea. It is very important that you understand all of the rights and options that I just explained to you. Before we go any further, Mr. Daybell, do you have any questions regarding what I've just explained, or do you need to discuss any of that with your attorney?
I have no questions.
Very well. Mr. Daybell, you were brought before this court to answer the information filed by the state, which alleges that you have committed serious crimes and that 4 felony charges have been filed by the state against you. You have the Sixth Amendment right to counsel at every critical stage of these proceedings, which I see you've already exercised as Mr. Pryor represents you here today. Before I allow you to respond by entering a plea to these charges in the information, I have a few questions I need to ask you. First of all, we've confirmed you can hear me okay this morning. Is that correct, Mr. Daybell?
Yes.
All right. Have you had enough time in your mind to review the information with your attorney?
Yes.
Is your name as listed in the information correctly listed?
It is, yes.
Thank you. At this time, your counsel has advised me that you would waive a formal reading of the information. Is that correct, Mr. Pryor?
It is correct, Judge.
All right, then at this time, the court will summarize the charges from the information that was filed by the state on August 17th. The information alleges in count 1, the crime of destruction, alteration, or concealment of evidence, a felony under Idaho Code 18-2603. That charge carries a punishment of up to 5 years in prison and a fine of up to $10,000. Mr. Daybell, do you understand that charge and the possible maximum penalties?
Yes.
Count 2, Mr. Daybell charges conspiracy to commit destruction, alteration, or concealment of evidence. That's a felony under Idaho Code 18-2603 and also Idaho Code 18-1701. That charge also carries a punishment of up to 5 years in prison and a fine of up to $10,000. Do you understand count 2, the charge, and the possible penalties?
Yes.
Count 3 is contained in the information charges destruction, alteration, or concealment of evidence, a felony under Idaho Code 18-2603. That charge also carries a punishment of up to 5 years in prison and a fine of up to $10,000. Do you understand the charge in count 3 and the possible penalties?
Yes.
And finally, count 4 charges conspiracy to commit destruction, alteration, or concealment of evidence. That's a felony under Idaho Code 18-2603 and 18-1701, and it also carries a punishment of up to 5 years in prison and a fine of up to $10,000. Do you understand that charge and those possible penalties?
Yes.
And I'll also explain to you, Mr. Daybell, those charges or the possible penalties in each count could run either consecutively, meaning together, or they could be ordered to be served concurrently. Concurrently would be running together, and consecutively, meaning one would have to be served after the other was completed. At this time, Mr. Pryor, is Mr. Daybell ready to enter his plea, or do you need any additional time to discuss this with Mr. Daybell?
Judge, at this time, we are prepared to go forward for the entry of a plea. Mr. Daybell, on behalf of Mr. Daybell, we will enter a plea of not guilty to all of the charges and obviously request a pretrial and a jury trial, Your Honor. Thank you.
Okay, thanks. Mr. Pryor, the not guilty pleas will be entered as to counts 1, 2, 3, and 4 in the information. With that then, counsel, let's discuss the time for setting of a trial in this case. We did have a brief discussion prior to the hearing. There was a suggestion that we look at January for a date for trial. Mr. Wood, how many days of trial would the state be requesting in this matter?
Your Honor, I think we should probably plan on, as we've discussed, about 3 weeks for this trial.
Mr. Pryor, your thoughts from the defense on how many days we'd need for trial?
Judge, as we previously discussed, I anticipate at least 3 weeks will be needed in this matter.
We could schedule trial to commence on January 11th through January 29th.
That's acceptable to the defense, Your Honor.
And that works for the state.
There is one federal holiday during that time period on the 18th. So that would have you losing 1 day. Is that still sufficient time, do you think, Mr. Wood?
I think that would work, Your Honor. I think we can figure that out.
All right. Any concerns with that, Mr. Pryor?
No concerns, Your Honor. Thank you.
All right. We'll set the trial then to commence Monday, January 11th. Council will intend to conduct full trial days. I won't be having any other hearings scheduled during the time of the trial. Just for planning purposes, we typically will run a trial to start every day at 9 o'clock and go until 5 o'clock with a lunch break. Let's schedule a pretrial conference then. December 10th at 10:30 a.m.
Works for the defense, Your Honor. Thank you.
It's fine for the state.
All right, we'll send out the notice of trial setting. Mr. Wood, is there anything further from the state this morning on this matter?
No, not at this time. Thank you.
Very well. Mr. Pryor, anything further?
Not at this time. Thank you, Your Honor.
All right, council will send that notice out. And if there is nothing else, then I appreciate your attendance and preparedness this morning, and we will be in recess.
Thank you.
Thank you, Judge.